There are so many young women who read It Ends With Us, and there are so many young women here tonight. So what do you hope that these young women take away from this movie?
I hope they feel seen. I hope they feel loved. I hope they feel empathized with, and I hope they feel like there's always hope. There's always an opportunity, whether that's yourself, from a best girlfriend, that you're not defined by anything any man has ever done to you or will ever do to you, that your identity is you and you define that.
Hey guys, welcome back to my channel. Blake Lively and Ryan Reynolds are going bananas in court, and yesterday Blake filed a motion to compel, she filed a motion for sanctions, and then today by a separate attorney, Michael Gottel, filed motion for sanctions on behalf of Ryan Reynolds. This is one of a zillion motions at this point that this couple has filed along with their publicist Leslie Sloan to delay the process to further attack Wayfair and to play games and game the legal system. And this new motion for sanctions is a lot like almost identical to what Blake Lively filed yesterday. And before I go into what they're doing and what these documents say and really what they're arguing and all of that is almost irrelevant, because I think at the heart of this we need to talk about what narcissists do in the legal system. Now, I'm not a psychologist, I am not a lawyer, but I have been sued by at least 3 narcissists, malignant ones at that. Every single legal case I have been involved in has had the exact same pattern, and I'm watching the same pattern play out against, Belon and Friedman and Wayfair and the Wayfair parties. Psych Central, which is a website for psychologists and for information on psychiatric issues and, learning about psychology, they talk about narcissism a lot and write about it a lot. And one of the big ways that narcissists attack their victims is by using the legal system to bully their opponents. So according to them, these are some of the common tactics you'll see of them in court. They will file frivolous lawsuits, filing senseless lawsuits that have little merit for the point of forcing the opposing party to hire an attorney and incur unnecessary expenses. Many times these lawsuits are dropped, but not until after the opposing party takes the narcissist's threats more seriously and perhaps has even succumbed to a demand. So I think when we look at Ryan and Blake, at least Blake's lawsuit, it's completely frivolous. She knows that nothing happened with a smear campaign, and she most definitely knows that no sexual harassment happened. But she's doing this to bully and threaten Baldoni along with her husband, Ryan Reynolds. False accusations. They will often beat their opponent to court by falsely projecting their issues onto the opponent. The false accusations forces the opponent to be on the defensive and causes the court system to frown when the opponent makes a similar charge against the narcissist. Do you see that? So they've already said we're going to file sanctions for Van Sham lawsuit and your attorneys are acting unethically and you have filed a frivolous lawsuit against us. That's what Wayfair has said, but they keep going to the court so that they can get ahead of things so that when Baldoni and Wayfair do respond, the court looks at them like they're crazy. It's just a part of the gaslighting entrapment. They will incite and encourage their victims to act irrationally and then call police on them. We don't have that here. Gaming the system. This is using laws designed to protect a person as a point of manipulation against them. For instance, not allowing a child to see or speak to the other parent on their time because it would give the other parent more time with them. I would say in this case, gaming, the system would be using the 47.1 in forum shopping, where they're trying to find the appropriate forum so that they can find the loopholes. And that's another whole number senseless motions and hearings in order to delay the process. They will file senseless motions, excessive hearings, and multiple postponements. This is again done to drain the financial resources of the opponent and create an atmosphere of the never-ending lawsuit. For a narcissist, all attention is good, so dragging things out longer only benefits their ego committing perjury. They will lie about matters that are not material and are inconsequential to the case just to anger the opponent. This is technically not perjury unless the lie is relevant to the outcome. The slight lie in the face of other statements further taints the whole testimony. Using loopholes, they love to find loopholes in the law and use it in their favor. However, if their opponent were to utilize a loophole against them, their attacks would be ruthless and jury tampering. They will bribe or intimidate members of the jury to make a decision a certain way. narcissists frequently believe they're above the law. So now that you know this framework, and I will put this link in my description box, you'll notice that a lot of what's happening is what Blake and Ryan are doing. They're using loopholes like 47.1 going to New York, using that DO lawsuit, and then running to the judge over and over and over again and accusing Belden of wrongdoing and Wayfair of wrongdoing when they're actually engaging in that exact same behavior, but worse. So right now, they are aware that they were exposed with the Vans sham lawsuit. Okay, and the Vans sham lawsuit was discovered in April. So a story went out. I was the one that discovered the lawsuit. I posted about it. The Daily Mail a day later discussed it. Even though they had a copy of the subpoena, her attorneys admitted that the subpoena for Jen Abel's phone records came from that sham lawsuit. And then a week later, after it was exposed suddenly out of nowhere, both Ryan and Blake are demanding Wayfair and the Wayfair parties of Heath Sorowitz, Abel Nathan, and it ends with Us LLC withdraw their complaints against Ryan and Blake, and if not face sanctions, accusing them of filing a frivolous action against them. So trying to flip the narrative and already try and then using this knowing full well that the court is about to hear about sanctions for them. Narcissists are very reactive. They don't oftentimes think the long term, and so they're very reactive when stuff happens. And what I noticed with Brian Friedman is that he plays the long game, and sometimes they bait you to react like they said. They trap you. So you get all of these demands and they're constantly yelling at you, and then you're reacting to their abuse, and then they use that like that, and then they go, see judge, I told you they're bad, Mr. Brian Friedman, and their motion to strike, which they're trying to get the judge to file sanctions because of the motion to strike, which is insanity. The judge already ruled that he would not sanction Brian Friedman for this. In their motion for sanctions, they're trying to allege that they filed these actions against Ryan and Blake so that basically the law firms would be able to harass them, which is not what law firms do. They're defending their clients. But because their law firm is always speaking to the media about Justin, I guess it's not harassment because it's true for them either way. But inside of these motions that they're asking for sanctions, the contents of these motions isn't super relevant unless you see what is being said to them by the other side. That's just my opinion because they're asking for something that's not going to be found. They're not going to get this motion for sanctions. I don't think I cannot see a judge ruling in their favor. And it's another way for them to play the victim. But in their exhibits in this, you hear directly from Brian Friedman's counsel. Okay. And so everyone is saying that this letter is from Brian Friedman. It's actually written by one of the associates at his firm, Ellen Gaup. Okay, but the letter was sent on May 13th. Okay, so May 13th was last Tuesday. This is the same day they were filing to quash the motion for the subpoena for Taylor Swift. And so they responded on May 13th. And they said the letters address alleged pleading defects that the Lively defendants have already placed before the court in their respective motions to dismiss the first amended complaint. The gist of the letters is that the FAC's extortion, defamation, and intentional negligence interference claims are stated on behalf of the Wayfair parties as a group and do not state facts sufficient to state a claim on behalf of a particular plaintiff swept into the definition of Wayfair parties. For instance, the Lively defendants threatened sanctions against Jimmy Heath, and on the asserted grounds that Mr. Heath lacks standing to assert an intentional interference claim, because the FAC does not allege that he is a party to the allegedly interfered with WME contract. He was the CEO of Wayfair. The FAC fails to plead specific defamatory statements about Mr. Heath that does so about others, included in the term Wayfair parties. As another example, the Lively defendants complain that Melissa Nathan is grouped under the umbrella of Wayfair parties in the FAC extortion claim. Even though only Wayfair Heath and Valdon are the proper plaintiffs, the Lively defendants also object that the FAC's false light claim is properly stated only by Baldon, Heath Abel Sarowitz, and not Melissa Nathan. Did you see that? They admitted that the false light claim is properly stated? Oh my good God. Simply put, group pleading is the defect at the heart of the Lively's defendants' Rule 11 letters. Such purported pleading defects, particularly those already before the court, in a motion to dismiss, are not the proper subject of a Rule 11 motion. Such motions are improper if they are substantially identical to the arguments made by a defendant in support of their motion to dismiss for failure to state a claim, and they use some laws to say that motions and amendments should not be employed to test the legal sufficiency or efficiency of allegations in the pleading, nor should Rule 11 motions be prepared to emphasize the merits of a party's position. So they're basically telling them you're only filing this to the court to just remind them about your emotion, to dismiss, to reinforce your claims against us, and that your emotions are great. And this is why they're like re-arguing their motion to dismiss. Again, this is what Leslie Sloan did with her motion to compel. The Lively defendants rule, 11 arguments are not merely substantially similar to, but the same as arguments asserted in their motions to dismiss, even ignoring the awkward fact that Rule 11 does not apply. Group pleading is a common practice, as expressly stated in the response to the Lively defendants' motions to dismiss. If the court deems the definitional issue to be a pleading defect, it is easily curable by amendment. A curable pleading defect does not rise to the levels of frivolous, legally unreasonable, or factually without foundation as required for Rule 11 sanctions. Put another way, if the court grants your client's motion to dismiss in whole or part, the Wayfair parties will amend the FACs as directed by the court, obviating any imagined Rule 11 issue. If the court blesses the pleading and denies your motion to dismiss any Rule 11 motion by your clients would be rendered frivolous. Indeed, the Supreme Court has recognized the flexibility provided by Rule 11b-3, allowing pleadings based on evidence reasonably anticipated after further investigation or discovery. Discovery is in its infancy, and the extensive allegations in the FAC support the Wayfair plaintiff's good faith belief that reasonable investigation and discovery will uncover additional evidence to support the claims of all Wayfair parties and plaintiffs. The Lively defendants' Rule 11 threat at this early juncture is, to put it mildly, premature, in addition to being improper during the pendency of the motion to dismiss. Finally, the letters cynically quote Mr. Freeman, whose statements are not pleading, filed with the court, and are thus outside the ambit of Rule 11, and since they have no relevance to Rule 11 sanctions, the only conclusion to be drawn is that the inclusion of the statements in the letter has no purpose but to harass and undermine Mr. Freeman and our firm with the court, the very conduct sanctions seeks to curtail. So they're basically saying that you're including what Friedman is saying in this lawsuit and what he's doing in the press as an effort to undermine his credibility to the public as well as to the judge and to harass him. And then they finally end it by saying in the Lively defendants, 12 letters claiming that the Wayfair parties have violated Rule 11 are themselves frivolous and contrived solely to harass and increase the cost of litigation. Such hardball litigation tactics, including threats of Rule 11 sanctions, are improper. Any motion for Rule 11 sanctions will be addressed accordingly. Certainly. Here's the rewritten paragraph with the timestamps removed and no changes made to the content. Part of Rule 11 sanctions in federal court is about attorneys not signing documents or filing complaints or motions or letters to the court for the sole purpose of harassing or intimidating or undermining or slandering someone. Okay, so it's like how they last week said, we need to strike this because it's abusive, we need to strike this because it's just trying to get salacious headlines when it came to Brian Friedman. And in that filing, by the way, the judge said, we are not going to sanction him. So attempting to go to the court now and trying to use what he said publicly again after the judge basically said we're not going to sanction him isn't going to work. He was put on notice about what to file in court and not to participate in that back and forth, but no sanctions. The judge said no sanctions at this time. So here's what I think is going to happen. There's a lot of ways that they can respond to this. They could absolutely file a motion to strike these, and they could claim that they're frivolous, that they are without merit, they don't have legal grounds, and that they're being done for the sole purpose of harassment and intimidation, and to garner headlines, exactly what they accused them of last week, because right now these are getting headlines that are positive for Blake and Ryan, which is what they want. They want the positive headlines looking like they're fighting against their bullies, right? They could also respond against this right? But then also argue in their response that the request for sanction is improper and frivolous, and as a result, they would like attorney's fees awarded to them for having to fight against this frivolous sanctions document that has no grounds or legal standing and is only being used for improper purposes. Misusing Rule 11 can get you sanctions as well. So if they bring forth a frivolous claim, they can literally file a counter-sanctions against them. So they can respond and counter and tell the court this is what they did, and this is why they should be sanctioned as well. They are inviting and opening the door to whatever is being held against them. And I think they're trying to bait Friedman to tell them what their evidence is, or, to push them in order to get sanctions for the Van Sham thing, or to suss out the evidence in the case so that they know what they haven't seen yet. They could be doing this for so many different reasons, but if you go back to that list I said about what they do in court, it's again to delay, to drive up costs, to further abuse, to get favor in front of the judge, to manipulate them because of what's going to come against them, so that the judge will think that both sides are participating in bad behavior. Their request for sanctions and their letter to them could have also been retaliatory. So say Brian Friedman and his law firm, along with Mitchell Schuster, may have sent them a safe harbor letter very similar, telling Blake to withdraw her claims based upon the fact that she obtained evidence through an illegal lawsuit and abuse of process, and also could have let them know we're seeking sanctions against the attorneys for the abuse of process in this case. So they could have filed this in retaliation for their safe harbor letter, but we don't know that they've sent it because we don't know what's happening behind the scenes, if that makes sense. Now, to be clear, since everything was filed last week with the motion to strike, Baldwin's team hasn't made a single statement to the public. But on the other hand, Lively's side has been out of control talking to the media, so they want to control what Friedman can do, but they want to do whatever they can do. When I look at it, if I pull myself back even from like a higher level than what they're asking, when I look at the meat of what it is that they're mad about these claims and the reputational damage it's doing to them. They're mad that the press and these claims are being used to show a side of them that they don't want the public to see. They want a gag order in this case. Okay, they want a gag order. They wanted to silence Friedman since day one. They've been arguing that any discussion about Blake Lively in the public is retaliation when it's not. They have a right to defend themselves, and what they're trying to do, at least in my opinion, is when you seek sanctions for these claims, and then they layer in what Friedman is actually saying to the public. Like, here's some of the examples that Ryan put in his claim. Ryan's involvement is very well documented, and we continue to discover more. Certainly. Here's the rewritten paragraph with the timestamps removed and no changes made to the content. Intentional misconduct. Was Disney actually complicit in Ryan using shareholder revenues to further a personal grudge? I would be surprised to learn that this type of corporate waste would not lead to much more exposure for those that have been complicit in affecting shareholder revenue. Another one was what I make of that nice pool scene in Deadpool vs. Wolverine is that if your wife is sexually harassed, you don't make fun of Justin Baldoni. There's no question it relates to Justin. I mean, anybody can watch that. The hair bun, if somebody is seriously sexually harassed, you don't make fun of it. It's a serious issue. As for Mr. Reynolds' appearance on Saturday Night Live, I'm unaware of anybody, frankly, whose wife has been sexually harassed, who has made jokes about that type of situation. I can't think of anyone who's done anything like that. So it surprised me. The immense power that Lively wielded in Hollywood, built on pure fear of her husband and their powerful friends, came to an end the moment Miss Lively planned a mass distribution of a disturbingly false and well-calculated hit piece in the New York Times. What he's trying to do is chill the free speech of Wayfair's right to defend themselves, and when it's being weaponized improperly like that to chill speech, which free speech is a constitutional right, and the judge already stated that they would not be placing a gag order, and he already stated he would not be sanctioning Friedman based on last week, and they made a warning to him, and Friedman hasn't said a word publicly since, and yet they keep going to the media to say whatever it is that they want, and giving statement after statement. And by the way, in many of these statements, he is responding to a statement that was released by Go Toddle or Ezra. So it's okay for them to respond, but not for Wayfair to respond. Do you remember when the text messages came out that she shared, and you saw the one where Jen Abel was telling Justin that they don't like it when you're nice to them because it doesn't represent what happened, but if you criticize them, they don't like that either, so you can't win. That's what's happening here. They don't like it when they say nice things. They don't like it when they say bad things, they just don't like it. They want to control what you can say. They're trying to take authorship of this lawsuit, and I don't know how they're going to respond. This is going to force Wayfair, I think, to bring a formal motion regarding the Vans sham thing. The Vans sham lawsuits, I think it's going to force them to address some of these issues that they have that they're working on, but I do think they could either do a motion to strike, they could do a really good response defense, or they could do a counter motion for sanctions. And when both sides are asking for sanctions, oftentimes they become moot to the judge because they wash each other out. So they're going to have to be pretty strategic here, but it's wild for them to accuse Mr. Friedman of being abusive in the court when these motions and 12 letters and these filings are abusive in and of themselves, in my opinion. As far as the motions to compel, I don't know how they'll rule on them. I don't know, because the judge doesn't seem super inclined at this point to make a ruling on discovery that's not closed until August, and because of the federal rules in the Second Circuit when it comes to motions to dismiss Lively and Reynolds are obviously getting antsy, that the judge hasn't ruled on their motions to dismiss, which were fully pled, I think, at some point in early April. Now, the Second Circuit has this benchmark guideline that they look at, and it's their rules for how they respond to motions to dismiss, as judges have in the Second Circuit, which is where the New York Southern District is located, have up to 180 days to either respond with an order on the motion to dismiss or schedule a hearing for the motion to dismiss. So they have to do one of two things. If they don't make an order on it within 6 months, a scheduled hearing has to come up, be made for an upcoming hearing at the 180-day mark. Now, if you search Judge Lehman's docket, you will find that in the past year and a half, he has been assigned over 320 cases. That's just in the last year. Some of the cases that he has, that he's getting on, he gets cases assigned to him daily. They all have deadlines, they all have schedules. Some of the cases are way bigger than this. Right? He's got cases that are on his docket that are probably 2 or 3, 4 years old. All of that is work he has to do. And so Lively's case is not his highest priority. There's other cases that have had motions to dismiss that have been waiting longer than this one. So he will often, in most judges, in my experience, they wait until the last minute because they have all this other work to do. And what they're trying to do, in my opinion, is relitigate and remind the court, listen, I've got these motions to dismiss, you really should use them. And a motion for sanctions is usually not common for attorney's fees unless you file it after the motion to dismiss is granted. So judges don't usually make a decision on if a case is frivolous before they rule on a motion to dismiss. So in one respect, they're almost trying to say to the judge, you need to rule on the motions to dismiss now, so it's twofold. They're impatient and they want to control the judge. That's how I see it, so that's what I have for this video. I could probably spend 30 more minutes on it. But what are your thoughts about all of this? Are you surprised? Not surprised. What do you think the next move is going to be for Baldoni and Wayfair? Tell me in the comments below. Please make sure to give this video a thumbs up. Please subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.